Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be how to beat rent control. Everybody, yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening to this broadcast live, the name of the song was Eye of the Tiger, and it was written and performed by the group Survivor. It was actually featured in the movie Rocky III in 1982. And a little known fact is that Sylvester Stallone wanted to use the song Another One Bites the Dust, which was written by Queen, but they denied him permission. So he commissioned this group called Survivor. He had heard this song by Survivor called Poor Man's Son, and he figured that they would be the best to write the theme song for this Rocky movie. And of course, it became a wild hit, Eye of the Tiger. Now, I picked that song for a specific reason, and that is because the opening topic today is how to beat rent control. So I figured this Rocky song would be perfect for that. Let's go over the show format. As we know, there is an opening topic. And then after the opening topic, for those people that are in the Zoom meeting, I will call on you and you can ask your questions and I will be happy to give my responses. If you do want to be called on and you're in the Zoom room, please electronically raise your hand because I do call on those people in the order upon which their hand was raised. Now, if you're watching this on YouTube, I'd appreciate it if you could hit that like button and also subscribe to the channel. Also, if you want to leave comments regarding questions that you have, if you're in the Zoom room, I'll get to those within the next few days and try to respond to your questions. And this just makes it much more enjoyable back and forth with regard to that. Also, if you have a topic that you want me to discuss on future shows, please put those in the comments in the YouTube meetings. Okay, let's get to the topic at hand, and that is how to beat rent control. How to beat rent control, ladies and gentlemen. Do you know what rent control is? Rent control is tenant welfare. That's what it is, tenant welfare. But unlike social welfare, where you have to meet certain criteria to take advantage of social welfare, with tenant welfare, you don't need to meet any criteria. Those people with substantial means are in the same position as those people with less means. And they get the same advantages of rent control, even if you have $4 million in a bank account. And unlike social welfare, where the entire populace pays for social welfare through their tax dollars, rent control is supported singularly by the property owner. There is absolutely no fairness with regard to tenant welfare, also known as rent control. Rent control is anti-competition. It's against the free economy upon which our country was formed. All persons in business have the right to receive market value for their goods and services. Our industry, residential income properties, are the only industry that is singled out to have to support other people individually. Clearly, this is not what our country is based on. Anytime that you can get around rent control, I consider that a laudable interest on your part. You're bringing back what it should be, the free economy. So let's see what we can do in terms of those aspects in beating rent control. So what can you do? Well, number one, whatever the politicians are giving to you, you take, okay? Don't rest on the situation, well, this rent increase is too small, I'm not even gonna do it. No, take advantage of everything that the rent control statute is giving to you, be it the statewide rent control or a local rent control. So for example, and this is a news headline, as of August 1st, 2024, state rent control is allowing an 8% rent increase. As of July 1st, 2025, LA City, for example, is allowing a whopping 3%. It doesn't matter how our uh, insurance bills went up. It doesn't matter how our costs went up in the building. This is after 4 years, they allowed us 4%, and now the next year only 3%. This is criminal, ladies and gentlemen. Also, for unincorporated areas of LA County, the current thing for small property owners, I think those with about less than 10 units, is only 2.93%. But my point is, regardless, whatever jurisdiction that you're under, you raise that rent like clockwork every single time that you do. You've got to take advantage of any of these statutes. Whether, even if you think your rent's at market level, it makes no difference. Raise that rent every year. Now, let's talk about some strategies that doesn't work for rent control. And that would be just make an agreement with your tenant to pay more rent than what the statute will allow. The tenant is willing to do this. Hey, I know I'm under market value, and I know that really I should be paying $300-400 more for the apartment. You're only entitled to give me like a $12 rent increase. Well, you know what? I feel bad for you, Mr. Landlord. I'm going to agree to pay more rent than what the law allows. Don't do it. Don't fall into that trap. If you do, 4 or 5 years down the line, you're going to find yourself with a lawsuit. They're going to ask for all their money back plus treble damages. Stay within the law all the time. We see a lot of this with Section 8, where Section 8 will only pay a certain amount, and the tenant agrees with you on the side. I'm willing to sign a rental agreement that I'll pay more money. Don't do it. Under Section 8 rules, you can only get the amount that Section 8 has approved. That even includes if you're in Los Angeles, where they're giving you this 3%. You can't just tell the tenant 3%. Those all have to be cleared through Section 8. So make sure that you stay within the law, because these other strategies are not going to work. For example, people think, well, I know how to get around rent control. I'm just going to move in myself, or I'll have a family member move in, then they'll move out, and great, now I can raise the rent to market value. That strategy does not work. For example, in the city of Los Angeles, they have a rule called last in, first out. So if you had two-bedroom apartments, one going for $1,500 because they've been there a long time, and the other one going for $3,400, they're going to make you pick the person who came in last. So that's number one. So you're not even going to get a real bump up in the rent, because you have to pick the person that's been there the least amount of time, the one who moved in last. In addition, for example, in the city of Los Angeles, you have to stay in that unit for 2 years. So let's pretend you did get a low-paying tenant out. But the truth is, after 2 years, when you move out of the unit, you have to rent the premises for the same rent as what the previous tenant was paying, plus any applicable increases. So this is a strategy that just does not work. And another one which people think is, if I'm the new owner of a building, then I get to set the rents for whatever I like. Again, that is not true. A tenant who is under rent control is protected regardless of who is now the owner of the building. So forget those strategies. So let's talk about strategies that do work. What are the strategies that do work? So let me tell you the story. If you evict a tenant for cause, not that you're putting in a family member, but because he's done something wrong, the law rewards you. And how is that? If you can evict that tenant because the tenant has done something wrong, once that tenant vacates, under the law, you have the right to raise the rent to market level. Well, this is great. So it's almost like our politicians, based on the way the law is written, is encouraging landlords to find a way to evict the tenant for cause. So let's go over those reasons that you can evict the tenant. One would be, of course, the main one, non-payment of rent. If the tenant's not paying you the rent, you serve a 3-day notice. If they don't pay within the 3 days, you have the right to bring forth an eviction. And once that tenant is evicted, you have the right to raise the rent to the next tenant coming in to market level. Well, that's a wonderful strategy. Now, let's pretend you have a tenant who's paying market rent and he doesn't pay the rent. Well, it's okay to wait a few days, a week, then maybe a 10 days, and then serve a 3-day notice, contact him, try to find out what's going on. You know why? Because that tenant's paying market rent. But if you have a tenant who's well under market rent, you want to immediately serve a 3-day notice to pay the rent. And in fact, least be known by many people, there is no grace period. Even if your rental agreement says there's a grace period, that just means when a late charge kicks in. You want to serve that 3-day notice immediately. If rent is payable on the 1st, under the law, it's due on the 1st and delinquent on the 2nd, and you have the right to serve a 3-day notice on the 2nd. If the tenant doesn't come up with the rent within the 3-day period, you have the right to bring forth an eviction. Now, a lot of people think, well, gee, if the tenant comes up with the money and brings it into court with me, then I have to take it. And the answer to that is no, that is not the law. It is not a 3-day notice plus whatever I feel like. It's a 3-day notice. So you want to serve that notice immediately, especially if you're talking about a low-paying tenant, because you're going to hope and pray that that tenant doesn't pay within the 3 days. Let me tell you one proviso with that rule. If the due date, and we're going to in this example pretend that the due date is the 1st, if the due date falls on a Saturday, Sunday, or legal holiday, the tenant would get through the next business day to pay, and therefore you can't serve the notice until the following day. So an example would be if the due date turned out to be the 1st, which was a Saturday, the tenant would have until Monday to pay the rent, and you could legitimately and legally serve that 3-day notice on the following day. Okay. What if your tenant's paying the rent on time? What else can you do? Well, if there's other violations of the rental agreement, you can evict. One would be extra people. If the rental agreement says 2 people can live there and they bring in an additional person, you now have the right to bring forth an eviction based on a violation of the contract. You would serve a 3-day notice to perform or quit, giving them 3 days to get rid of the stranger. If the stranger is still there at the end of the 3rd day, you've got him. We can then bring forth an eviction. And when everyone is evicted, again, bring the rent to market value. Now, people always ask, well, how do I prove that this guy is there? And I respond to that, just use your eyes. If you can see this stranger coming and going, for the last few days, you know what kind of a car he drives, and that car is parked overnight. You see him walking into the unit with his key or leaving in the morning. That's all you need. Do you have to have video? Video doesn't hurt, but certainly you and maybe another person who can come into court and testify that the guy's living there. We don't have proof problems with regard to that. Other things that we can evict on would be for an unauthorized pet, like a dog. We would serve a 3-day notice. The dog's still there at the end of the 3rd day. That means we can bring forth an eviction. How do you prove that the dog is there at the end of the 3rd day? Well, generally, the owners are going to take their dogs out for a walk, so that's not going to be hard to prove. Also, if you knock on the door, guess what? The dog's going to bark, because that's what dogs do. So that's another way that you can evict a tenant. Now, of course, you have to be cognizant of the fact that if they bring you documentation that this is a service animal or an emotional support animal, then that wouldn't work. But unless they do that, having an unauthorized pet is a wonderful ground to evict. Also, you're dealing with tenants who do not keep the premises sanitary. In every rental agreement that you have, it's going to say that tenant has to keep the premises neat and sanitary. If the tenant is not doing that, serve your 3-day notice, asking him to clean up within the 3 days. And if he doesn't, you've got grounds to evict. Other ways that you can evict the tenant would be if they've altered the premises. Let's pretend they put up a satellite dish or one of those Ring doorbells, or they painted a bedroom chartreuse, or maybe they changed the locks. If they've changed the locks on this property, then you have the right to bring forth a notice to perform or quit, and they've got to supply a key to you within the 3 days. If they don't do that, you've got grounds to evict. And again, remember what we're trying to do here. If we can figure out a way to evict the tenant for cause, once that tenant vacates, we now can raise the rent to market level. We're doing your patriotic duty by trying to bring forth a freedom of our country, and therefore, with regard to the Constitution of the United States, we're acting as we should act. So there's no shame in evicting a tenant to get your rents up to market value, not to mention the exponential value bringing forth to the value of your building. Now, what if they're not violating any specific terms of their rental agreement? Can you do something else? And the answer is yes. Look for non-operational cars. If this car is not operational, if it's inoperable, you have the right to evict. Almost every municipality has laws against having an inoperable car on the property. So if that's the case, we would serve a 3-day notice to either remove the car or make it operational within the 3-day period. And of course, they don't. That would be a beautiful case for eviction. Also, if your tenant is creating a nuisance, he's yelling, he's screaming, threatening other tenants. Well, of course, you should want to get rid of that tenant anyway, just for that reason alone. But again, once we do, we have the right to raise the rent to market value. Now, another way we can evict tenants under certain circumstances is by doing a substantial renovation. Right now, under the Just Cause Ordinance for the City of Los Angeles, that has been banned, but that revocation of that reason is ceased to exist as of August 1st, 2025. Also, if you have property located under the auspices of statewide rent control, then again, you have the right to evict the tenant for substantial renovation. So either JCO properties effective as of August 1st in the City of Los Angeles, or any property subject to statewide rent control. If you've got low rents, oh my God, let's take advantage of this loophole, which is substantial renovation. Now, what is that? Well, that is where you're going to substantially renovate the unit, rendering it uninhabitable for at least 30-day period. And also the work that you're intending to do requires that you obtain a building permit. So what you need to do before calling my office is get yourself a contractor who will give you the scope of the work, which will therefore show that the premises will be uninhabitable for more than 30 days and that the work that he intends to perform will require a building permit. You get that permit, and now with the permit and the scope of the work, we can easily start an eviction to get rid of this low-paying tenant. Now, in the City of Los Angeles, if we're talking about a single-family home, it's only 1 month's renovation, 1 month's relocation. In statewide rent control, it's only 1 month's relocation. But for the City of Los Angeles, for JCO properties, it does go up if it's not a single family residence, anywhere from $10,000 to $20,000. But if you can substantially raise the rent, oh my God, you guys got to do that. So that's a wonderful tactic that you can use to, quote, beat rent control. And the last one I'm going to talk about, which is your path of the last resort in terms of beating rent control, is to offer your tenant a voluntary vacate agreement. If the rent is $650 for a 1-bedroom unit, and you know that you can get over $3,000 for that unit, it is a smart deal, ladies and gentlemen, to offer that tenant $30,000, $35,000, because it is legal to offer a tenant to move. And if the tenant agrees in writing to vacate the unit, at that point, you have the right to raise the rent once that tenant moves out. And in fact, it's easier than a renovation eviction if you get them to agree to move. but it all depends how much money you want to throw at your tenant. Again, there's no specific amount. It could be $1, it could be $100,000. It's whatever the tenant and you agree on. But if you can get your tenant who's in an apartment that's paying very low rent to agree to move, that's worth a lot of money. $2,000 difference in rent, that's worth at least $35,000 to you. You're going to get your money back in about 18 months, and yet you've increased the value of your building exponentially. So, ladies and gentlemen, that's the topic of how to beat rent control. If you take advantage of any of these items, you will be way ahead of the game. So stick with it, and maybe you can get your property up to market value. We are now going to open it up to questions and answers. We know the ground rules, and that is these answers are for informational purposes only. It's not a substitute for legal advice. If you do want to talk to me and you're in the Zoom room, please electronically raise your hand. Also, this broadcast is for general questions only. If you do have a specific case with my office, please call the office. I don't want to discuss it on air. And also, if you are talking to me, please leave your camera on because it makes it much more enjoyable if everybody can see everybody. And again, you guys in YouTube, please hit that like button, subscribe to my channel, and please feel free to leave comments with questions or suggestions for future shows. And with that, I'm going to open it up to our first caller, and that is Tony C. How are you?
Good afternoon, Dennis.
Hello, Tony.
Thank you. I just want to say that we just did our first rodeo together, and to be honest, it was painful, but at the end was real worth it because I was able to rent the unit basically $1,000 after repairs, compared to the other tenants. So, we did one that it went well. So my question is, you kind of answered it, but today I had an inspection, and with this particular tenant, the unit is always a shamble. He has this large, this is like a king size bed in the living room, and when I sent someone else to do the inspection this morning, he couldn't hardly find which way was the bathroom. And before I give him the notice to comply, we find out that it's one smoke detector that is not working. So do I need to fix the smoke detector before I give him a 3-day notice to comply?
No, I think if there's an extra person living there or the premises are so cluttered that it's not considered neat and sanitary, then you can serve a 3-day notice for both of those items and then proceed forward with an eviction.
All right, great. Thank you so much.
My pleasure. Okay, thank you, Tony. Moving on to, let's see if I can pronounce this guy's name right. Let's see. Oh, yes, Jim Polina. How are you, sir?
Pretty funny, Dennis. Pretty funny. Happy Saturday. So I'm modifying my lease a bit. I think I might be pushing the boundaries here. I got 2 clauses that I need your comment on. One is that I'm advertising the rent at $3,300, but in the lease I have the gross rent at $3,400, and right below that I have a line of $100 discount for maintaining the house. And I put this more verbiage for describing how to maintain the house. The idea is I have some quick and easy leverage to increase the rent if the tenant is not maintaining the house. And the reason for that, I'm allowing him to have like 4 pets in the house. So I'm worried.
I don't like that idea. First of all, if you're advertising it for 33, then you got to rent it for 33, even though you're, quote, giving a discount. And then if you went into court with regard to the fact that, hey, now the rent's $3,400 and I can prove that you didn't maintain the premises, that's just way too speculative. So, Jim, I love you, but I don't like that idea.
A little too creative. Okay, here's another one for you, Dennis. All right, the garage. I want to provide the garage, or the rent does not cover the use of the garage. The garage is being provided as an accommodation. I'm not providing a separate lease for the garage.
If you have in your rental agreement that the garage is just an accommodation and you can remove it from the tenancy at any time, then I don't have a problem with that.
Okay, and I also have in there that the security deposit covers any damage to the garage.
Again, if the tenant damages any place on your property, I think that you're allowed to deduct that from the security deposit.
Okay, so yeah, okay, so I'll use that one then.
Works for
Thanks.
me, sir. Let's move on to Laura Coral. How are you?
Good. How are you, Dennis? Thank you for providing us this space weekly and providing us with important information. I have two questions. The first question is regarding the 30-day advance notice change to the rental agreement. So I provided tenants back in December this notice making effective February 1st. Of course, the rent increase along with my availability in person. Now, I live in a 6-unit building and I live on the property. And I have this one tenant that she's just very confrontational. And she comes and she starts recording me. I tell her, like, I don't authorize or approve that you record me. And she accuses me of, like, every time I give her the rent receipt that I throw it on the floor. And then when I enter her apartment, I vandalize it. And I just want to avoid conflict with her in person. So I want to go ahead and change that, my availability time to just, hey, just call me. I want to avoid all in-person interaction. So can I go ahead and provide all tenants with the 30-day advance notice change to the rental agreement with just my availability?
I don't have a problem with that, but let's pretend you do that. And then she comes knocking on your door. Then what are you going to do?
I don't open it.
So you're telling everybody that I will accept your phone calls. Please don't come to my door. I'll accept your phone calls and I'll also take something in writing like an email. Is that what you're saying?
Yeah, I could go ahead and do a text. You could go ahead and drop off any repair
I,
notices on
I,
the door.
I just don't see this
Yeah.
going anywhere because you're going to be walking to your car and she's going to walk up to you. Then what are you going to say? You're going to say, hey, I changed the terms. You can't talk to me. She's going to be berating you. So I think you have to put her on notice that she is creating a hostile environment and therefore she's becoming a nuisance. And that if this conduct continues, that you're going to have grounds to evict. That's why I would send her a warning letter on that. Okay.
My question is, so I put that my availability is like Monday through Friday between 11 a.m. and 4 p.m., but I'm actually going to be going on vacation. What's a proper way to notify tenants? Like, hey, I'm not going to be around. Do I have to notify them or?
Well, but people can still be notified even when you're on vacation through your cell phone. They can text you. So just say, I'm not physically, as a courtesy, I'm physically not going to be on the property. But if you need me, text me or, or send me an email because you can always check that. And then, let's pretend, you need a plumber. Well, you have your vendor list, I'm sure. And even if you're going to Nova Scotia, you can still call that plumber and get
Yeah.
him over there within the same hours if you were home.
Okay, so I don't need to like a drop off a physical notice on the door letting them know that I'm not going to be available in person during a certain time frame.
No, no,
Okay.
you don't ever have to be available in person. They can call you, Everybody's got a cell phone.
Oh, okay. And I have a question in regards to the grounds to evict. Let's say the tenant, which is very confrontational, she went ahead and she put a camera, a wired camera, outside her door. I asked her to remove it. She didn't remove it. But because I've collected rent, if I were to go ahead and go to court because of this, like, would I be able to evict her or would I lose the case because I've already collected rent, knowing that she has that camera out there?
The fact that you collected the rent is not a limitation of you going forward to evict this tenant based on an alteration to the property. The only issue would be is once you serve the notice to perform or quit to get rid of that camera that's on the exterior
Yeah,
of the property, then at that point you can't take any rent.
got
So
it.
you've got a good case for eviction.
Thank you.
All right, thank you. Let's do here. Leslie Hope, how are you?
Oh, I can't complain. Um, I have an issue. During at the beginning of COVID, I allowed a family member to live in a vacant apartment. I partially furnished the apartment with the basics, but turns out he's a hoarder. And now he's creating, well, like you say, a hostile environment. And so I need to get rid of him. And
Does
how
he pay any rent?
no rent. I've
Okay,
never
so what city is this?
City of LA, and it's a non-rent controlled apartment.
Okay. Well, all apartments are rent controlled. So you're either under JCO or you're under
No,
statewide, but you're
it's
under something. In any event, this is not a problem
not
whatsoever.
city.
Has the person been there less than a year? Just out of curiosity?
No, he's been there ever since the beginning of COVID. That's like probably about 5, 6 years.
Okay, so this is a type of eviction that we do all the time called a tenancy at will. It
Mhm.
requires that we serve a special 30-day notice. The person doesn't have any, quote, tenant protections because he's not a tenant because he doesn't pay rent. So
Right.
this would be a case that our office could easily handle for you.
All right, I'll call you on Monday.
All right, thank you. We are moving on to Sonia. How are you?
Dennis, hi, I'm doing good, thank you. Um, Quick question. My question is regarding to like appliances. We have single family house in city of LA. We do have tenants in there, but the AC was having an issue about 2 weeks ago. They let us know. We sent someone down. We got an estimate, but long story short, it looks like we're going to put in a new one. So there's been a delay with the, I guess, the contractor or the people ordering it. My question is, so I'm aware of the 30 days and its central AC needs to be changed. We're at 2 weeks now, so I just want to make sure as long as we get the new unit in within 2 weeks, we're good. We're not going to have any problem with the tenants wanting to decrease their rent or anything.
I don't think so. I mean, you do have to act reasonably. I'm not sure about this quote 30-day rule that you're referring to, but
Oh,
as long as you act reasonably to get a new unit in, first you thought the unit needed to be repaired. Unfortunately, it couldn't be repaired.
yeah.
Then you had to go negotiate to get a new brand new air conditioning in there. I don't see that the tenant would have any cause to start discounting his rent.
Okay, thank you. Thank you so much.
All right. And we are moving on to an old regular. Harold, how are you?
There you are. You know, I was listening to this Best of Dennis the last couple days. There's all kinds of good stuff. It's like endless Dennis. Um, so there was the lady I was telling you about who they were going to pay her to leave. She has a husband getting a divorce. And the more I think about how this thing's getting crazier, I'm thinking this should just be a referral for Dennis now. Can you hear me?
I can. You broke up a little bit.
Did you catch me or no?
I heard that
What I'm
they're
saying is,
trying to offer money to a tenant to move, a friend of yours. Go ahead.
yes. And then the husband out of the blue, I didn't realize this. She didn't tell me this, but he's always had like a bunch of cars in the backyard, like 8 of them. He really doesn't live there. He just uses the place. He's the guy on the lease. Him and her is on the lease, but he signed it. Is it not working or what?
It's working, but I think I'm hearing you, but I think your bandwidth is less. So I would advise your friend, and then we are going to move on. I would advise your friend to get those cars out of there immediately because, as I stated in my opening topic, that if they've got cars that are inoperable, and it seems like they are, then
Yeah.
the landlord could easily bring forth a case for eviction. So
Plus
you
the
want to
garage.
tell her to get that out.
Okay, good answer.
And we are moving on to, says here, LKJ LC. I'm going to ask you to unmute yourself.
Hi, Dennis. Can you hear me?
I can.
I've got a problem here. Got a 20-unit building in the city of Los Angeles. I've got a problem tenant who hadn't paid. I went through with an eviction. I got a judgment of eviction. I sent the paperwork to the sheriff. This was done in January. Then in April, the sheriff posted a notice, 5-day notice to move out, and they sent me a letter that they schedule a lockout date for June 4th. And then a few days before June 4th, my tenant went into court with a emergency motion asking for a delay of eviction. And the judge basically put off the eviction until the 20th of June. The judge basically gave me time to respond to oppose that and put off the lockout date. The sheriff can't lock out until after the 20th of June. Now, I'm not concerned about beating that motion. I'm concerned about, am I going to have to reschedule with the sheriff another lockout date again? That's going to be 2-3 months out, or what? Because that lockout date, I had to wait like 2 months almost to get that lockout date.
Let me answer the question so we can move along here. If you win your motion on June 20th, then the court will then send the sheriff a notation that, hey, you can go forward with the lockout. Yeah, you're going to have to wait another 2 to 3 months. I would say no. You should call the sheriff's office and speak to someone in charge and say, look, we already had a lockout date for this property. I don't want to go to the back of the line. So, and kind of encourage them to give you a quicker lockout. That would be the best way to handle it. And I thank you for the question. We are moving on to Daniela Moskowitz. How are you? Daniela.
There we go. Hi, Dennis. A quick question. Is it legal to charge a penalty of 1.5 times per diem for lease overstays?
I don't see any problem with that. If in fact obviously you have to be in a jurisdiction where there's no rent control whatsoever and no good cause to evict, because otherwise the tenant doesn't have to move at the end of the lease period. But I see that a lot in commercial rental agreements, and I don't think there's any problem in a residential rental agreement, assuming you're not subject to any rent control at all.
So if it is in LA City, it's not advisable because they can stay and pay the
They
1.5
can
times.
stay even if it's a single family home. They can stay.
Got
And
it.
the lease is over unless it was within the for 6 months. Then if you asked them to move and they didn't, you could say for any holdover you have to pay X amount. That I wouldn't have a problem with.
Okay, great. One quick question. Do you have a referral for service agents for us to put on the lease?
So what type of service agents?
A service agent
Oh, I
like
see what you're saying, where somebody will be able to
receive
accept
any
goods or
kind
service. They have some companies, I think one is called CT Service, which will act as your agent, and they're authorized to accept lawsuits. So,
okay, and you suggest we
CT
use
Services,
that?
I think what their names are, but you can just do a Google for search and you'll find it.
Okay, good. Thanks.
Yeah, agents to accept service, just do a Google search. Okay, moving on to Jonathan Kennedy. How are you?
I'm well, thank you. I wanted to just make sure that if I had a tenant vacate, I gave them a notice that they can reclaim their abandoned property that was over $700 worth. They did take away all their property. It was all outside the house. But they left we currently have about 4 or 5 vehicles, and I think that I can have them just removed under vehicle code 22658. That would not be included in the $700, would it?
No, you're not going to hold a public auction because those cars have their own title to them. So yeah, you just want to get them towed off and you have the right to do so.
Okay, great. Thank you.
No problem. Nice talking to you. Moving along to Brett's iPhone. How are you, sir?
Hi, Dennis. Appreciate the time. Your firm is handling a just cause eviction for me in a Los Angeles RSO property. Today is the 60th day The tenant has been very reluctant to comply.
My good friend, we don't talk about specific cases.
Okay, so if the tenant has moved out but have not returned the keys, or removed a lock from the garage space, is there any downside to sending them a reminder text that today is the last day and there's a 1 week of unpaid rent?
I would definitely send that and say to the tenant, have you moved out? If they say no, then obviously you have the right to bring forth an eviction. If they are silent, then I would go into the unit, serve a 24-hour access notice to go into the unit to see if the premises have been abandoned. If everything is out of the unit, then at that point I would just take pictures and then change the lock so as the place is yours. As to the locked garage, that seems pretty suspicious to me that there might still have stuff in that garage. But again, you have the right to check inside that garage by cutting through the lock if you have to see if in fact the premises have been abandoned. But your first avenue would be to first contact your tenants and see what their position is, if they will respond.
And if they don't respond at all, and today is the 60th day,
Then what I would
don't
do
have-
is I'd serve notices to enter on the basis that you want to check to see if the premises have been abandoned. That form is on my website at Evict.
How do
123.
how do I serve that notice if they're not? Again, they have left the property.
Well,
But-
if they've left, they've left. So, but you would put that notice right on the front door. That's all.
Okay. Thank you.
All right, no problem, sir. And we are moving on to Ray Razapur. How are you, sir?
Yes, hi, Dennis. Thanks so much for taking my call. This is the first time I have a chance to speak with you. I really appreciate that. I read your kind of an agreement regarding the mold from last week, and I was wondering, would it be a good idea to have this signed by tenants at the time of renewal as a standalone policy, or should necessarily be included in the actual lease agreement? Because the way I renew the leases with my tenants is that they send us, we exchange emails saying, hey, this is the new rent, and all terms and conditions remain the same. Agreed, end of conversation for the new lease agreement. And the second question that I had before
let's one at a time, my friend.
Okay.
When they move in, you have a rental agreement, and I have a mold addendum. So they'll sign both the mold addendum and the rental agreement. If the lease is renewed, there's really nothing further you have to do. Now, if your rental agreement doesn't have a mold addendum or paragraphs dealing with mold, I have on my website a change of terms of tenancy. So just send that to them, and then in 30 days, and that becomes a term of their rental agreement. In both of those scenarios, you also include the mold tips, which I also have on my website.
Okay. All right, great. Thank you. Then my last question is, I hear a lot about the County of Los Angeles and the issues that they have with landlord and tenants. What is your overall understanding of how things are in County of Riverside in terms of landlord and tenants relationship? Is there anything substantially different from Los Angeles or Orange County? Thank you. That's all I had for today.
Absolutely, it's different because Riverside is a civilized place to own property because they don't have rent control, with maybe the exception of the city of Palm Springs. So basically, those jurisdictions, you're under statewide rent control. So you're allowed, for example, as of August 1st, if you're under statewide rent control, to raise the rent 8%. Of course, you do have to have cause to evict. But if you're, and I've said this many times, and that's regardless of where your property is located, if it's a single family home or a townhouse or a condominium, you do have the right to raise the rent to market level, notwithstanding any other law. So anyway, thank you very much. And moving on to Nishan, how are you?
I'm fine, thank you, Mr. Dennis. And this is the first time I get the opportunity to talk to you. And also, thank you very much doing this. It's very helpful people like us new for this business. And I have two questions. I will ask the first one. I have a tenant 2 years, year-to-year lease agreement, and this time he like to go for month to month, and I have never experienced before. And I checked your website also. I didn't see the form for month to month. What should I do, and what is the advantage, disadvantage to do that?
What city is the property located in?
Los Angeles Resida.
Is this an apartment or a house?
It's a ADU.
Okay. And the ADU, I presume, was built after within the last 15 years?
Yes, 2023.
Yes?
Yes.
Okay. So on my rental agreement, there's a box to check that either says fixed term lease or month to month. So a rental agreement does exist. But since he's already under a rental agreement, once that rental agreement expires, it automatically, by operation of law, becomes a month-to-month rental agreement with the same terms and conditions. So you don't necessarily need to have him sign a new rental agreement if he's just going month to month. But if you do want to have him committed to another term, like a 1 year or a 2 year term, then you do need to get him to sign a new rental agreement.
So when I go to month, I'm planning to increase a little bit too. So how should I do? Just write an email and say we are going month to month, and
Well,
this is going.
yeah, it's just by operation of law. If he stays there past the 2 year period, as soon as he pays the next month's rent, that would be the 25th month's rent, then that now tenancy is month to month. That rental agreement still is operable. All the terms exist. It's just now month to month.
Okay, I hear you. So my only concern, like if we have to go just in case into court or something, I don't have proper documentation, have like month to months that we agreed
But
upon.
you
That's
do,
all.
my friend. You do. That rental agreement, that old 2 year rental agreement is
Yes.
his rental agreement. It's now month to month. We do this all the time where we
Yeah.
file lawsuits based on that type of an agreement.
Thank you very much. And my second question, sir, he looked like bringing a girlfriend like time to time. I didn't bother him. He just indicate here and there. Maybe I don't know how long because I'm not going observing. It doesn't bother me at all. It's keeping the property nice and clean also. So in legal perspective, should I take any action or just let him go as it is because he's a good tenant so far?
Well, what you're saying to me is that this person is not a permanent occupant, that she comes from time to time. And any tenant
Yes.
has the right to have a person come in from time to time. You know, my
Yes.
grandma from Oklahoma can come in and stay there for 2, 3 weeks. Once they're there more than 30 days, then they do, the law does look at them as permanently residing on the property. And then you could either add them to the rental agreement or you could bring forth an eviction based on the fact that they're violating the terms of their contract.
You mean, Mr. Dennis, like even the agreement say somebody stay like more than 14 days in a given year, so it has to be notified. But it's very difficult to count the days and ask, hey, notify when do you have a visitor? It's just
This is the ADU we're talking about, correct?
yes, yes.
Okay, so the bottom line is that it still needs to be 30 days before they gain occupancy, notwithstanding whatever your rental agreement says. So if they're there more than 30 days, then they are considered to be occupying the property, and then that would trigger you to either put them onto the rental agreement, or conversely, you could bring forth an eviction. Anyway, thank you very much. We are moving on to Pamela Rich of Los Angeles.
Hi,
Pamela.
Dennis. Oh, wait, am I off video? Hold on, let me do this. Does that work?
you-
Can you see me?
Oh,
Okay.
I see you.
First of all, I'm a realtor. Thank you so much. My questions have to do with just cause property, single family home, condo, ADU. I always told my clients, when I have a single family home in Tarzana, they get $15,000 a month. My clients were always told they can raise the rent when they want, what they want. And the tenant's been in there 1 year. They would now like to raise the rent. They wanted to raise it more than 10%. They wanted to go from 15 to 20, but somebody told them that if you raise the rent of more than 10% and the tenant's response is, that's too much, I'm gonna go, the owners of the property then have to give her a month's rent. So in this scenario, at 15 grand, we say we want to raise it to 18, and she says that's too much. My clients then have to give her $15,000. Is that correct?
They have something in the city of Los Angeles called economic displacement. It is a totally illegal law. It's being challenged by the Apartment Association of Greater Los Angeles, and it's working its way through the court. However, it is the law that if you serve a rent increase notice, which you have the right to do, and the tenant says that's too high, I'm going to leave, then the tenant is entitled to relocation. For a single family home, it's 1 month's rent.
Crazy. Okay, thank you. And second, can you just go over the new law regarding photos and the move in, move out? My experience has been a tenant moved out, and the damage was he put a plant potter in a very unique corner that, of course, any photos that we had before isn't going to get every corner of the house. So how do we best take these photos, whereas when there is a damage and we don't have that actual corner from the before?
Okay, well, first of all, as of April 1st, and this question got raised in the last show, so I'm glad you brought it up. On April 1st, you have to take pictures of the premises after the tenant vacates, and then once you finally restore the unit. So I don't know how this planter is going to be in your way. This is after the tenant vacates. You're supposed to take pictures of how the unit looks, which would demonstrate all that damage that he created. And also, once the premises are restored, and those pictures have to be included in your security deposit itemization. And
I
then a
understand
new,
that, but
let
you're
me
saying
finish
that,
though.
sorry.
And then a new law states that as of July 1st coming up, that you do have to take pictures of the unit when you're going to be leasing it to a new party. So like before they move in, you have to take pictures. Go ahead with your question, Pamela.
My question was just that. So like with this planter, I understand we have to show what it looks like with the damage and the look like when we fix it, but the backup, he's saying, well, show me what it looked like before I put my planter there. And we don't have photos
Well,
of every
well,
corner.
but that's fine. You're not going to have a photo, but you know that stain didn't exist on the floor from the water leakage when you rented it to him. You're right. You're not going to have it, but again, for the new law coming effect as of July 1st, you are going to take pictures of the premises before you leased it out. So then that would
Every
solve your
corner.
problem. What's that?
Photos of every corner, of every ceiling, of every blemish. Like one time we had damage of the ceiling in the shower. Like we don't necessarily photograph every corner of every house. Do you know what I'm saying?
I do. So why don't you take a picture of every corner of every house? What's the problem?
That's what we
It's
have to
just
do
a
now.
couple of minutes to take pictures of the ceilings and of the floor. I don't see a problem.
All right. I just didn't know if it's every corner. Okay.
All right, thank you, darling. Moving on to Zena. How are you?
Fine. How are you, Dennis?
I'm good, thank you.
All right, I got two quick ones. Is it against the law to charge, have it in my rental agreement that there will be a $25 fee if I have to provide you with a 3-day notice or, some type of notice for paperwork, administrative work fee?
I had that in my rental agreement. I thought it was a great idea, but they changed the law on us, and that's not permitted anymore.
Okay. And so then the second one is also regarding the law. If I'm going to rent my home to a person and not the garage is not included in that rental, is that against the law? And can I just just say something like that in my rental agreement that the garage is not included in this rental agreement?
You can definitely exclude a garage from your rental agreement. Just make sure that you properly note that, and there's nothing illegal about that.
Okay. Thank you so much. You rock. Have a great week.
Thank you so much. Anna Cecilia, how are you? Anna Cecilia.
Hi, how are you?
Good.
Great. I'm a realtor too, and I actually sent you a client and she's very happy with the results. So Anyway, I own a house and I'm leasing it out to an assisted living home. Recently, my tenant has been paying me the rent late. I'm not applying the late charges, but if I were to ask them to leave, do I need to proceed with a 3 days notice as normal, like any other place?
Okay,
And
well, first of all, what city are we talking about?
Burbank,
Okay, so Burbank. So right now, is any rent owed?
is any what?
Is any rent owed at this moment?
No, he luckily brought it to me late, but he brought it yesterday.
And this is an apartment or a house?
A house.
Only
it's
one
in a-
house, only one house on the lot?
Yes,
And when you leased out that house, did you put a paragraph in that rental agreement stating that this property is exempt from statewide rent control?
I did not. That was, they've been there for 11 years.
Oh, okay. So then you don't need that. No, you don't need any reason to evict. We could just serve a 60-day notice in that situation.
Even though it's an assisted living home where he is renting the room to elderly people, 62 and older.
Oh, so wait a second. So I missed that part. Sorry about that. So you're leasing it to him, but he's then having other people live there in rooms, but you only have one rental agreement with him, correct?
That is correct.
And did you use a residential rental agreement or a commercial rental
A
agreement?
commercial.
Yeah, I still think you could, in that situation, you could just serve a notice, and he and his assisted living persons have to also get out as well.
Okay. And what would you suggest? Since they've been there for so long, would I need to do a change in tenancy and do another lease?
Well, it's just going to be a notice. Well, if you want him to move, you're going to serve a notice to quit. If you want to change the terms of the tenancy, I would have him sign a brand new rental agreement.
All right. Okay. Thank you.
Thank you. Moving on to Gid Martin. I think you're a newbie here. Say hello.
Hello. No,
Hello.
this is. Can you hear me?
I can.
Okay. I'm also a real estate broker. Let me put my video on. So I have a condo unit that I took it off the market, and I went through all this RSO crap. It's in the city of LA, 90043, and I'm putting it back on the market, the rental market. And my question is, one is it better to do month to month or lease? And the other question is, what is the best way to put it back on the market?
Okay,
Is there
so
anything I need to know?
I'm a little confused on this. First of all, your camera's not on, if you want to click on that. But notwithstanding that, now I see you. Right now, the premises are vacant, correct?
Yes.
Okay, so then you could put it back, and this is a single family home, or what kind of a property?
Condo.
It's a condo. Was the condo built after 1979?
No.
Okay, so you're under RSO, so it doesn't matter whether you do a year's lease or month to month. You might as well at that point do a year's lease. And then you're going to need to register that condominium as a rental with the rent stabilization ordinance for the city of Los Angeles.
And if I don't, is there a penalty or something? Of
Well,
course.
technically, you can't demand rent from your tenant unless it's registered. So you definitely need to register that unit.
Okay. And there anything I can do that, to better scrutinize? Since I've been doing this for 40 years. I've been a landlord for 30 years. But what's the best way do you guys have a way of scrutinizing? Do you have a questionnaire or anything to
Well,
scrutinize?
we have an application on our website. We also have the renter's criteria on our website. You might want to take a look at one of our previous videos where I really talk about how to get a good tenant and how to kind of spot the ones that are going to give you some trouble. So take a look. If you go to my website at evict123.com, there's a button at the top that says previous shows from Zoom Landlord Tenant Talk Radio. Click on that, and you'll see a couple of shows have dealt with how to get a good tenant. Anyway, thank you very much, Gid. Appreciate you coming on. And we're moving on to Janie Bishop. How are you?
I'm excellent. How are you?
I'm good, thank you.
I'm a realtor too. And I saw you on Angel and Patty yesterday. And
Oh, yes.
And so I thought, I better come and here today. So a potential client that wants to sell a property and the tenant has been there and is paying well under market.
What city?
Los Angeles.
Is this a house or an apartment?
Well, a house with a recently in the last couple of years converted garage to ADU, but the tenant is in the house portion.
Right. So once that ADU got built, magically that house is now under rent control for the city of Los Angeles.
Okay, so they can't be exempt, huh?
No, they can't.
Oh, okay. So what options do they, because you can't evict because you want to sell.
That's correct. You can't. That's our crazy system of law. So what you can do is just try to do a cash for keys or a voluntary vacate agreement, as I described.
Yeah.
That would be about it, unless the tenant's doing something wrong, like not paying the rent or something to that effect.
Yeah. Thank you very much.
And thank you. Okay. Okay, we've made it through another edition of Zoom Landlord Tenant Talk Radio. I do appreciate everyone coming out and making this show what it is. And we'll be back here next Saturday at 3 p.m. Or you can watch it on YouTube because I will edit the show after this broadcast. And again, those people who are watching on YouTube, please hit that like button, subscribe to the channel, and leave some comments of questions you'd like me to answer or topics that you'd like me to discuss on future shows. And with that, everybody, have a great weekend. Take care.